Pros and Cons of Arbitration, part of the series Global Business Law in 20 Minutes with Federico Vasoli. That is your topic for today. Welcome to the Lawyers and Mediators International show and podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
And Natalia Oskaczajka, attorney, mediator, and arbitrator from Warsaw, Poland.
And Federico Vasoli, originally qualified in Milan, Italy, managing partner of the MTV Global with offices in Singapore, Malta, and Vietnam, currently recording from Italy.
All right, guys. So we're back with Federico, and we're going to segue very quickly from the last part one episode we had, which was talking about drafting arbitration clauses. And now we're going to segue over to pros and cons of arbitration. So, Federico, why don't you get right into it? Go ahead.
Yes, first of all, I would like to apologize with you and our audience for being cut off due to a power outage here in the countryside. We were discussing a so-called multi-step arbitration clause in the previous episode. So I was very briefly saying that there is discretion given to the parties in what elements to include in the arbitration clause. It could be the venue, well, first of all, the arbitration center. Secondly, the venue. Thirdly, the number of arbitrators. Fourthly, the substantive law. And that's pretty much it. There are, of course, other details that can be discussed, that can be agreed on upon the discretion of the parties. Now, it could be that essentially for economic reasons, that is to save on money, arbitration is generally regarded as an expensive procedure. The trade-off being that a court case would last forever, and you may want to spend more to have a faster solution of your case, especially if you run the risk of the other party becoming insolvent, disappearing, etc. So unless there are some urgency proceedings, injunctions, etc., injunction reliefs, etc., that could be used to freeze the assets to make sure that the other party doesn't disappear. Typically, arbitration is considered good for a number of reasons that we're going to discuss, but typically also because it's faster generally than going to court. Now, because of the perception, it's not necessarily true that arbitration is expensive. Some companies, it happened to me a few times, may choose to elect two different arbitration centers. One for smaller cases. It is subjective, of course. The threshold could be $10,000, $1 million, $10 million, you name it. But for whatever you consider small, you go to an arbitration center that is relatively cheap and that is okay even if you lose, let's put it this way. But if you want to have a more prestigious arbitration center, one that gives you more certainties, one that maybe is specialized in a certain industry, that has a panel of arbitrators to choose from that come from specific industries, that have specific expertise, etc., then beyond a certain value of the case, you go for the second one, which is more expensive but is better. Let's put it this way. So, for instance, I have a client in Vietnam that manufactures sneakers, and for smaller cases, they go to the Vietnam International Arbitration Center in Saigon, which is perfectly fine. There are foreign arbitrators that are qualified to render arbitrations there. They speak different languages other than Vietnamese, but it is not considered as prestigious as the Singapore International Arbitration Center, which is, so to say, the arbitral center in Southeast Asia. So for cases beyond a certain amount of money in value, they elect this second arbitration center, which is the Singaporean one. So the clause reads something like, in the event of a dispute that cannot be solved amicably between the parties within, let's say, 30 days, 60 days, you choose, the parties choose to submit for exclusive adjudication the dispute to the Vietnam International Arbitration Center in Ho Chi Minh City with one arbitrator substantive law, the one of Vietnam, proceedings will be in English. Well, they just copy paste the clause from the Vietnam International Arbitration Center. For disputes whose value is beyond X, then, and they apply the clause of the Singapore International Arbitration Center. So in a nutshell, this is what I call the multi-step arbitration clause.
Speaking about the pros of arbitration this time, not mediation, which we normally talk about, what else do you think? You are saying that might be more expensive, but will be quicker. You are saying it is far more flexible. And what else can you say would be beneficial to the party choosing to go and have an arbitration clause and potentially go into arbitration rather than the court, the public court in a particular country?
I would say, first of all, you can choose specific arbitration centers for specific topics. One of the complaints that I hear the most about from clients when they go to court is that judges may be versed in the law, but they're totally ignorant about the industry, about the topic that is the subject matter of the case. So especially when it comes to highly specialized businesses, the tech industry, engineering, stuff like that. The complaint is, well, this judge may know everything about the law, but is totally ignorant about how my business works. He doesn't understand. So, and by not understanding the technicalities of the business, he will not understand where the faults are, where the tricky practical aspects are, and what causes typically a dispute. By the way, one thing that I always insist on doing when I onboard new clients in the manufacturing industry is to always visit their factories, because I want to know exactly what could go wrong in terms of defectiveness of products. So this is one advantage. The other advantage is that arbitration is jurisdiction neutral. So if you have a party from Vietnam and a party from Malta, you can definitely go to Singapore, apply Singaporean substantive law, and then have the arbitration enforced in both Vietnam and Malta, because they're both signatories to the New York Convention on the Recognition of Foreign Arbitral Awards, which we discussed in the previous episode. So these are the two main advantages.
Okay, Federico, well, go ahead and give us some positives, because by the way you made it sound, it would be a good thing all the time to always just go to arbitration instead of going to see a judge or a jury. So, can you shed some light on some negatives?
Well, the negatives is, first of all, costs. Even though it is not necessarily true, it really depends on first of all, let's define the costs. I mean, if the cost of an arbitration is in monetary terms high, but going to court means you waste 15 years of your life, even to win a case, but what for after so much time, then the trade-off is certainly in favor of the arbitration. And secondly, there are arbitration centers that are not so expensive. For instance, the European Court of Arbitration, seated in Strasbourg, is decently priced as an arbitration center. So these are still the positives. The negatives, well, there is a lack, if you want, of state control, of sovereignty over arbitration. It's private justice. So you have a sort of democratic deficit when it comes to that. It is difficult to appeal an arbitration award, because generally, unless you provide for a specific appeal procedure in the arbitration clause itself, you win or you lose, and that's it. And then you don't really neutralize the risk of a lengthy and even expensive court case by going for arbitration, because either party could challenge the validity of the arbitration clause in the very first steps of the arbitration and could say, stop, sorry, I know that you started arbitration, but I am going to court. I deem that this court has jurisdiction over the case, and I'm asking the court to render their view over the validity of the arbitration clause. So this way, they already stop you, and maybe they stop you for several months, if not years. And then even when the arbitration procedure is finished, you can still go to court to challenge the legality of the award itself. In Italy, there was a very famous case in the 1980s and 90s, which saw two big tycoons, one of them happened to become Prime Minister of Italy, Silvio Berlusconi, over the sale of a media company from another tycoon, Mr. De Benedetti, to Mr. Berlusconi's group. I don't really know the details of the case, but essentially this thing dragged forever and it ended up in the Supreme Court. So a negative aspect is that you think that with arbitration you're going to neutralize the lengths and the technicalities of an ordinary court case. Reality is you may end up discussing really fine details in court and still wasting time and money. So these are the, and then of course also you may say that judges are not generally prepared on highly technical matters, but at least they have been selected, whatever the selection procedure for judges is. Arbitration centers are privately run, so the three of us could, in theory, set up an arbitration center. If we are good enough at promoting it, that's it. But you two are good. I may not be as good as you, so I could render a horrible service to the people and the companies that go to our arbitration center simply because I'm not good at it. So there is no public concours. Again, it's the preeminence of state rules of federal, state, whatever government rules that is in a way lacking, because depending on where you set up the arbitration center, you may escape a number of rules and you may render these services even if you don't have a particularly complicated qualification.
And speaking of negatives again, the arbitration rules usually mirror this or other civil procedure.
Yes.
However, the arbitration, in my understanding, doesn't have the power that a public court has. For example, the power to bring the witnesses with force, the power to find the witnesses or experts who are not turning up on time. Can you say something about that?
I can only confirm what you say, Natalia. That is, yes, this is the case. It really depends on the arbitration center that you choose. It depends on the rules that you apply. But yes, this could be a limitation. And again, it adds up to the amount of money that you spend. That is, if you have to ask for arbitrators to travel all the way from one place to the other, they're going to charge quite a lot of money in billable hours or days, plus travel expenses, etc., which is certainly something that will not happen with a judge that receives a salary normally from the state. So again, do they work in their interest because they want to make money by billing days and hours of work, or are they rendering a general service to the community by providing justice, pretty much like judges do? I don't know. The debate is open. I mean, judges are public servants and they're not necessarily doing the interest of the people. They may be biased politically or in any other fashion, or racially, or etc. So I'm not saying that one is better than the other, but I'm picking up on what you said, Natalia, to insist on the fact that there may be some flaws, even big ones, in arbitration.
Do you think that online arbitration might, I guess, save people money in a way that it creates a new incentive for arbitrators to produce, good work at a really cost-effective method? Because now with Zoom and online mediations and online arbitrations, you can basically arbitrate from anywhere, even though parties are physically, two different destinations. And so I would think that that's a big factor, that the use of technology that has not existed before, and
I
video
agree.
telephony.
I agree. And there is also, again, the case for the access of the people to justice. Online arbitration goes in that direction. I remember having a conversation about it with a fellow lawyer from India that was describing to me the functioning of online dispute resolution in India. And coming from a country, Italy, that has a strong and old legal tradition and is quite conservative, I told him, but isn't it weird to render arbitration online? I mean, I would like to see my interlocutor, the judge, the witnesses, the other party, because, it's basic communication rules. Meeting in person is always better than meeting virtually. And he added a compelling argument. He said, yes, you may be right, but think about the geography and the social strata of India. We have millions of people that live in small villages where there is no court of justice. The closest court of justice is maybe 1,000 kilometers far from them, and they don't have a vehicle to go there. And even if they do, they will need to find accommodation, etc. And it may be very uncomfortable and inconvenient to do all this. But everybody has a mobile phone, so or a computer. So having access to online dispute resolution is a fantastic way to render justice. And I totally agree with this view. So yes, online dispute resolution is a great tool. It also helps with tech giants and in general with big multinational companies. Because bringing a company to court, one of these giants, is always a headache. It's expensive. You need to find the right lawyer. You need to notify, blah, 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 blah. But if you have tools, especially for small cases that involve consumers, you didn't repair my phone, my computer is still faulty and stuff like that. So small things that are still nonetheless quite annoying, then these tools could be really convenient, even when they don't have a human on the other side. I'm taking a step further. Arbitration, well, not arbitration in this case, but dispute resolution rendered by AI could be quite interesting also in for the sake of saving on costs. AI, artificial intelligence, would learn from previous cases. And here we're talking about standard issues. We're not talking about human rights. We're talking about, I don't know, the screen of a mobile phone that is broken. You bring it to repair, it cracks again, and it's still under guarantee. If the artificial intelligence bot learns from previous cases that the screen should not break after repair for at least, I don't know, 2 months, 6 months, 1 year, unless there has been an accident to the phone, then you don't even need a human to provide for that decision and to tell the tech company you need to repair the phone again. So yeah, we're moving in that direction.
And now, once again, to something that we touched upon in the previous episode that was about drafting the arbitration clause. The legal position of the mediation agreements, the arbitration agreements. I wanted you please to touch upon the New York Convention, so the benefit it gives, and the language comfort it will give you, meaning the language you choose for arbitration.
So the New York Convention is an international treaty that was signed by the vast majority of countries in the world that essentially states that an arbitration rendered in one of the countries, one of the jurisdictions that are signatories to the convention, is considered as rendered in any other jurisdiction that is a signatory to, that is a party to the convention. That is a fantastic pro for arbitrations because we know how difficult it is, even in our European Union, to enforce a national judgment in a different nation. In Europe, in the European Union, we have certain instruments like the European injunction form to recover sums of money from from companies and individuals in other member states. But for instance, the US is already a case on its own because you have to abide by the rule of just procedures, just process of law, and due process of law in the US. That is, you have to provide evidence of certain guarantees given to the subject that you are suing in America before you can even start legal proceedings there. So in bureaucratic countries like Vietnam, where the language is very difficult and you need to follow a number of formalities, stamps, notarizations, etc., it may be extremely hard to have a favorable sentence enforced. With the New York Convention, that can be avoided. You simply petition the competent court to apply, to enforce that judgment, and that's it. The only headache could be that you might have to translate it into the language of the court, but it's nothing compared to the complexities that you have to go through when either suing somebody in another country or when trying to enforce a sentence rendered in a different jurisdiction. As for language, yes, very simple. You choose the language of arbitration, and that's it. So if you go to court in Vietnam, you need to be defended by somebody that knows Vietnamese perfectly. There's not just fluent, but speaks the jargon, etc. Even in Vietnam, if you go to an arbitration center in Vietnam, you can choose to speak English, Polish, Spanish, whatever, French, and if the other part is okay, if the arbitration center has arbitrators that speak whatever language you have chosen, that's fine, and that's it.
Awesome. Well, thank you so much, Federico, as usual. So we're going to have you back and we'll continue this conversation more on business law with Federico Vasoli in 20 minutes. All right, guys, until next time, make sure you subscribe. Take care.
Thank you. Bye-bye.
Bye.